let's talk about the very important topics of polity. The first one is demand for including Ladakh under the 6th schedule that deals with special areas which need special attention. So let's talk about it, and there have been growing demands with respect to including Ladakh in the 6th schedule. 5th and 6th schedule are very important from the perspective of giving special status to certain states which are tribal in nature and which need special attention. And the demand was made in order to safeguard the land, the cultural ecosystem, and the employment in the Union Territory of Ladakh. Also, the National Commission for Scheduled Tribes has recommended the same. So, advisory role of the National Commission of Scheduled Tribe, this is very important that it has advised the government to do so. If included, Ladakh will be the only union territory to be included in the 6th schedule. Other than Ladakh, in the 6th schedule, if it gets included, there is Assam, Meghalaya, Tripura and Mizoram. Only 4 states are there. And also bestowing such a status to Ladakh would require constitutional amendment. All right. Also because it is dealing with a schedule. It is estimated that more than 90% of Ladakh's population is tribal in nature. Then why not? And the primary scheduled tribe in Ladakh are, write their names if you can or take a screenshot: Balti Beda, Bot or Boto, Brokpa or Drokpa, Dard Sheen, Changpa, Garra, Mon and Purikpa. So these are the important tribes of Ladakh. Remember, if it is ever asked in preliminary examination, what are these? And the names of the tribes are given. If you have remembered the name, you will be easily answering that question. Inclusion in the 6th schedule will help in the democratic devolution of power in the region. That means the local authorities which are at the ground level know the situation of Ladakh at the ground level. They will know what is best for their people. And if governance is devoluted in Ladakh, that will create a lot of opportunities for the Ladakhi population. It will also enhance the transfer of funds for speedy development of the region. Funding is also something that gets in the way of development, so that will also be taken care of. The 6th schedule contains special provisions with respect to the administration of tribal areas. Remember that. Tribal areas, and that is in the states of Assam, Meghalaya, Tripura and Mizoram. Apart from Assam, Tripura, Meghalaya and Mizoram, other states which have their scheduled, their population in majority of scheduled tribes, they are situated in the 5th schedule. Okay, moving on. Now the provision of the 5th schedule, this is the question, previous year question, so be very careful. The provisions in 5th schedule and 6th schedule in the Constitution of India are made in order to protect the interest of scheduled tribes, determine the boundaries between states, determine the powers, authorities and responsibilities of Panchayat, protect the interest of all border states. So, of course, as I have already told you, and the answer is already marked, you must be knowing that it's in the protection of scheduled tribes. Moving on, let's talk about the next topic, that is Prohibition of Child Marriage Amendment Bill. Now, this bill, the Union Cabinet has cleared this proposal to bring uniformity in the marriageable age of men and women, which is 21 for men and 18 for women. Now, it was seen that because of this, you can see this was not equal, it was unequal. Because of this, many girls were losing their opportunities to have a good educational program for themselves in the future after 12th. Most of the girls complete 18 years of age within, if they're in school or after just out of school. So after that, they might not get the opportunities to become a graduate, a postgraduate, and then explore opportunities in the work arena. So they, because there was a legality, a kind of passive legality, that it's okay to get married after 18. So in order to bring uniformity, first for education, employment opportunities, second to also make sure that fertility is kept stable. The earlier the girl gets married, the earlier the fertility rate will be exaggerating in the future. So second was also that. And third, why treat both the genders unequal? The legal age of marriage for women will be raised from 18 to 21 years. and the bill amends the Prohibition of Child Marriage Act of 2006 and other personal laws. These are the other amendments, and these are the acts in which amendments are to be made, such as Indian Christian Marriage Act 1872, Parsi Marriage and Divorce Act of 1936, Special Marriage Act of 1954, which gives protection to interfaith marriages, Hindu Marriage Act of 1955, then we have Hindu Minority and Guardianship Act of 1956, Hindu Adoption and Maintenance Act of 1956, Foreign Marriage Act of 1969. Alright, moving on. Let's talk about demand of special category status for Bihar. What is it? Now, Bihar government has reasserted its requirement of being a special category state in front of the center. It is this category who provides this category status to any state. The center does it. If it is asked on your examination, be careful with that. Now, this SCS is given by the center to assist development of states because they are facing geographical and socio-economic disadvantage. If these two premises are there, because of which the state is not being able to develop properly and prosper properly, then special category status is given. This classification was done on the recommendation of the Fifth Finance Commission in 1969. This is a preliminary fact. Please be careful and remember this. Who gave the classification? Fifth Finance Commission in the year 1969. Okay, moving on. Now, it is based on the Gargill formula. If it is asked what is the Gargill formula, you know what it is now. And the parameters for the special category status were hilly terrain. That means because hilly terrain, they lack proper infrastructure, they need special attention. Low population density, where the population is pretty scattered in nature, or sizable share of tribal population. If any state has a huge share of tribal population which is not developed socially, economically, and also educationally, then this status can be given. Strategic location across the borders, along the borders, specifically for India, protecting such states from the aggression of countries like Pakistan and China becomes a must to give special category state, because we want them to be developed and strong. Economic and infrastructure backwardness, if there is, and non-viable nature of state finance. So these are the many parameters on which the special category status is given. Prelims can ask you questions with respect to this, like from which amongst the following are the accurate parameters to give a state a special category status. Hilly terrain, you can also see low agricultural output. This could also be one of the false feature. You have to make sure that you remember everything so that when the question comes, you are able to take the correct answer. Now, special category status was first ever accorded to Jammu and Kashmir, Assam and Nagaland. Remember these three names. Straightforward question can be asked. And that was in 1969 when Fifth Finance Commission gave its recommendation. And then 8 more states have been added, including which states? Remember the names: Arunachal Pradesh, Himachal Pradesh, Manipur, Meghalaya, Mizoram, Sikkim, Tripura, and Uttarakhand. Most of these states have a boundary with international, with other countries, like international boundaries they are having. So you see that how international boundary plays a huge role when it comes to SCS. There is no provision of SCS in the constitution. So if it is asked in your preliminary examination, the categorization of SCS is garnered from the Indian constitution. No, it's not mentioned. Center pays 90% of the funds required in a centrally sponsored scheme to SCS. Okay. So as it is 90%, that means it is a central sponsored scheme. If it was 100%, that it could have been a central sector scheme, right? Moving on to the next thing, unspent money. First of all, features of becoming an SCS, what happens? The unspent money doesn't get lapsed and it gets carried forward. So financially, the state becomes very strong. Also, significant concessions are provided to these states whenever excise and custom duties, income tax and corporate tax are into the picture. Also, the concept of SCS, it ended after the recommendation of the 14th Finance Commission. You have to tell me in the comment segment who was the chairman of the 14th Finance Commission. Now, special provision for certain states between Article 371 to Article 371J has been provided. Okay, like Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, and these are included. Okay, So remember the names of these states. Again, next in line to be discussed about is National Courts of Appeal. The National Court of Appeal has been said to be made by the Attorney General of India, and 4 Court of Appeal would be made in which 15 judges will be residing. That means they will be residing over the matters. Each could act as an intermediate appellate court between the state high courts and the Supreme Court. So it will be like between the state high court and the Supreme Court, in order to lessen the burden of these on these courts, because Supreme Court, the judiciary in general, is very clogged, it's overburdened with work, and that is why justice is being delayed. So in order to create a proper segmentation of work, this National Courts of Appeal has come to act as an intermediary between state high court, Supreme Court. Okay, they would absorb cases such as trivial cases that are actually making the bulk of the cases, matrimonial disputes, rent control cases, and these 2 cases are such cases which have overburdened the courts. The judgment of these courts of appeal would be final. This is a prelims fact. Remember that. Judgment will be final, and this would unburden the Supreme Court, and that will only be used. The Supreme Court will be required to just pay attention to the constitutional matters and matters which can actually provide a predetermined framework of for high courts, state high courts, and the lower judiciary to have as a record for pronouncing different judgments. If the Supreme Court takes up more provides more attention to the constitutional matters, what will it do? It will provide a huge help to the lower courts, who would effectively use the judgments of the Supreme Court towards their own matters, towards their own cases. Okay, and the Supreme Court will deal only with such matter related to constitution and center state disputes, and NCA system exists in United Kingdom. National Court of Appeal system is there in UK, England and Wales. These 2 also have a court of appeal, and that is the second only apex is the Supreme Court. After that, we have Court of Appeal in England and Wales. And Constitution does not have any mention of the National Court of Appeal. Remember that. In the Constitution, we do not have any mention of it. Okay. And Supreme Court shall sit at Delhi or such other places or place. This is stated in the Article 130. And this shall be decided by the CJI, Chief Justice of India, and that would be approved by the President. Who will approve it? The President. Article 130, with respect to that, where the Supreme Court will sit, it will be decided according to Article 130, and the CJI will decide it. Approval will be done by the President. Okay, moving on. Now let's talk about new health law draft. The government has started the process of finalizing various provisions of the draft bill for a new national public health law. Health is actually in the state list, but there is a growing clamor for including health in the concurrent list because of COVID-19. The proposed National Public Health Act has been in the works since 2017. So India saw the importance of health pre-COVID time. And once it will get enacted, it will replace the 125-year-old Epidemic Diseases Act 1897. And this act has been so much in the news, question could be framed. So please do Google about it from an authentic source. Read about Epidemic Disease Act of 1897. And the draft bill proposes a 4-tier health administration. Public health authorities at national, state and district and block level as well, so that rural regions can also be integrated into our health ecosystem, because rural areas are the receiving end of the any kind of issue with respect to health amenities. Authorities will have power to take measures for the prevention of non-communicable disease and emerging infectious disease. Of course, COVID-19 has played its part in this particular provision. National Public Health Authority will be headed by the Union Health Ministry. A question could be framed. National Health Authority would be chaired by the Prime Minister, would be chaired by the Health Secretary, would be chaired by some other institution, you can say. But no, Union Health Ministry will play a part here. Proposes the creation of public health cadres at national and state level. So cadres will be provided at national and state levels only, not district, not block. The draft bill has defined various measures such as isolation, quarantine and lockdown. So a definition is very good so that any judicial interpretation could be more precise. Okay, moving on to the next thing. The draft lays down several situations in which public health emergency can be declared. That was the time and that was very needed. Bioterrorism, when any country wages a war in India by using organisms, that is known as bioterrorism. Okay, appearance of a novel or previously controlled or eradicated infectious disease or biological toxin. A natural disaster is also given. Chemical attack or accidental release of chemicals, and also nuclear attack or accident. So any possibility of anything has been undertaken by this. If it is asked in the prelims, what are the definitions and what are the you can say parameters on which emergency, public health emergency can be declared, and these options are given. So you will know which one is correct. In addition to something else will also be added which is false. Then you will know what is the correct answer. You will mark accordingly. Okay, moving on. Retirement age of judges is going to be our next topic. Now, the retirement age of judges of Supreme Court and High Court has been an issue since a very long period of time. AG for India has made a pitch for increasing the retirement age of judges, first because it is actually not yet proven that 62 and 65 years have any scientific backing if the person after that age becomes of unsound or unfit mind or unfit body. First that. Secondly, because the judiciary is overburdened with work, why not increase the age of judges for retirement? And currently the age of retirement for the High Court judge is 62. Okay, remember this. For Supreme Court judges, it's 65, right? So remember the difference. For High Court, it's 62. For Supreme Court, it's 65. And Venkatachalya Commission report recommends the raising of the age limit for retirement. Which commission? Venkatachalya Commission. The commission was set up to review the working of the constitution, by the way, and this was one of the recommendation. In this context, Constitution 114th Amendment Bill to rise the retirement age of High Court judges to 65 was introduced in 2010 but never got passed. It is still pending. A country in which justice is one of the premises of the basic structure of the constitution, this seems very, very contradictory, right? Moving on, if we talk about Article 124 and 270, they mention the maximum age limit for retirement of judges. So Article 124 and 217 is related with the retirement age for judges. 124 clause 2 says the maximum age limit for the retirement of Supreme Court judge will be 65 years, and 217 clause 1 states that 62 shall be the age of retirement for the judges of High Court. Okay, moving on, the upper age limit for retirement of HC judges was earlier 60 years and then it was increased. So why not now? It was increased to 62 only in the year 1963 through the 15th Constitutional Amendment Act, something to be remembered, because this has been in the news and an issue since a very long period of time. That's why. Same provision applies to additional or executive judges of the High Court. So this is also a prelims fact. It could be twisted and asked otherwise. Parliament can change the retirement age of Supreme Court and High Court judges. Who can do so? Governor? No. President? No. Parliament can do so. Okay. Moving on. Election Laws Amendment Act of 2021. Now the Election Laws Act, Amendment Act of 2021 has been passed. It wants to link the electoral roll data and voter ID card with Aadhaar ecosystem so that bogus votes can be eradicated. The opposition members have of course raised many issues. Now it amends what? Section 23 of the Representation of Peoples Act of 1950. Remember this, please. Okay. And it enables the linking of the electoral roll data with the Aadhaar ecosystem to prevent the menace of multiple, bogus votes that have happened in India, multiple enrollment for same person at different location. First, because it can happen that a person has been enrolled at multiple location and that creates a problem. Also, bogus voting for 4 qualifying dates will be declared for updating the voting rolls, and it will be done to include those who have turned 18 the first day of the months of January, April, July and October. So whenever phases will occur, the thing is that burden will not be put on for one single year. So it's in phases. Remember, January, April, July and October. The language for registration of wives of service voter will now be replaced by spouse. Now it could spouse in the sense, first you see women are also in the in certain service for armed forces, right? And they might not be able to have their vote given at certain period of time. But what happens that it was only providing wives, for the term was wives of the service voters, but now it will be spouse. It could be either a man or a woman. Also gender equality, and secondly also same-sex marriages, if it ever gets proper legalization in India, for that as well. Now this will make the laws gender neutral. Experts have said that the absence of robust personal and data protection law, any move to allow sharing of data can prove to be problematic, because with the help of Aadhaar we can access a person's personal information, which is not yet protected, because the data protection bill is still a bill. It has not become an act. Okay, moving on to the next thing. The proposed linkage between Aadhaar and election card or electoral rolls will make data available to the Election Commission of India and the UIDAI, the authority for Aadhaar. This could lead to infringement of privacy of citizens, which is protected under Article 21, right? Article 21. And which case is related with it? The Puttaswamy, Justice Puttaswamy case of 2017. The government justifies that the proposed linkage between Aadhaar and election database is voluntary. Now this is a pre-question. Remember that it's voluntary in nature. It's not compulsory as of yet. Let's look at our previous year question. It says, consider the following statements. The Election Commission of India is a 5-member body. Union Ministry of Home Affairs decides the election schedule for the conduct of both general elections and by-elections. Election Commission resolves the disputes related to splits, mergers of recognized political parties. So we have to select the correct statement. Only the third statement is correct. Okay, and there is no mention of Election Commission being a 5-member body. Right now we have one election commissioner, one chief election commissioner and 2 election commissioners, and this could also fluctuate according to the work burden. Earlier we had only one chief election commissioner. Before that, after that it was changed to 3 when 2 election commissioners were added, like that. Okay, Union Ministry of Home Affairs decides the election schedule. No, Election Commission does, and Election Commission resolves the disputes. This third statement is correct. Moving on. Another question, right to vote and to be elected in India is a fundamental right? No, it's not mentioned anywhere. Natural right? It could have been, but natural is more related to the nature of human beings. And constitutional right, yes, it is provided for in the constitution by different amendments. And legal right, these all, apart from fundamental rights, these 3 are somewhat matching, but the most appropriate would be constitutional right. So this is how we will answer the question. Now, Criminal Procedure Act of 2022, let's talk about this. Criminal Procedure Identification Act of 2022 has been passed to ensure more efficient and expeditious investigation of crime by the use of modern technology. Okay, so modern technology such as artificial intelligence, such as information communication technology, such as Internet of Things, brain mapping, everything is with respect to this particular bill. However, the provisions enabling the collection of biometric and biological data, this raises serious question about the validity of this particular act, because again it infringes upon the right to privacy, right to life and liberty, and that is why it is something not very, it's not holding any water. It aims to replace the Identification of Prisoners Act of 1920. It was proposed in the 1980s though by the Law Commission of India in its 87th report. Another very important fact for us to remember, in its 87th report, it has been suggested so by the Law Commission of India in the 1980s. SC judgment of the state of UP versus Ram Babu Misra in 1980. So if it is asked in your prelims examination, the name of the case and what it is related to. Suppose state of UP versus Ram Babu Mishra, it is related to the criminalization policy, like identification of criminals. So if it is given, you can add that. Okay. And the criticism and the need for amendment was predominantly in respect of the limited definition of measurements as under the Act. So because the measurement was having a restricted definition, this was done. So the bill has come forward, the Act has come forward. It will allow the police and the prison authority to collect, store and analyze physical as well as biological samples. That includes retina and iris scan. Okay, so two things are included, retina and iris scan. The who are the in charge of collecting, storing and identifying, analyzing? Police and prison authorities. These provisions will further be made applicable to the person held under any preventive detention law. So right now it is not so, but will be further made as a provision for preventive detention as well. Keep this in your mind, as prelims might ask. So it also authorizes for taking measurements of convicts and other person for identification and investigation in criminal matter. Who are other person? What is the definition of other person? It is still not defined. So how we will know that it won't be abused? This provision is very susceptible to abuse. Moving on, the previous law allowed taking only fingerprints and footprint. Now iris scan, retina scan has also been included for a limited category of convicted person. Now conviction is there, but other persons are not there previously, but it has now been included. This will make the investigation of crime more efficient and expeditious, and will also help in increasing the conviction rate, because although prisoners are overburdened, they are spilling with people who have allegedly committed a crime, conviction rate is not a lot. Okay. However, the phrase biological sample is not described further, so we do not know what other things can be included. It's very open to abuse. Then it could involve bodily invasion, such as drawing of blood and hair, collection of DNA sample that could be further used for blackmailing a person. There are acts that are currently requiring the written sanction of a magistrate. The legislative proposal undermines the right to privacy, as I've already told you, of not only person convicted of crime, but also every other ordinary Indian citizen if they are included in it. Apprehensions have also been raised that the law enabled coercive drawing of sample. There is already so many cases that have come to the fore when coercion has been used to take out testimonies, to garner testimonies. What about this particular bill? It could be a step in the wrong direction if the challenges are not addressed. This involves the violation of Article 20 Clause 3. 20 Clause 3 protects anybody against self-incrimination. Nobody can testify against themselves. I cannot testify against myself. The bill implied use of force in collection of biological information, could also lead to narco analysis and brain mapping. The earlier I said brain mapping is included. That means that was a challenge that I included, okay, on the similar grounds. Moving on. Now, the Act allows the records to be preserved for how many years? 75 years. That's a lifetime of a person. It undermines the right to be forgotten. Right to be forgotten is also a part of Article 21. We have already discussed it in our first episode of Polity PT Special. Although the Act provides that an arrested may refuse the taking of samples, but who will care? If they are in jail, in the eyes of the prison authorities, they are already convicts. Not all detainees may know that they can indeed decline, because they are not aware. How will they know they can decline biological samples? Because yes, if they are not well read with the facts, or they have not been made aware from the authorities, of course they will not know so. So it's an infringement of not only Article 21, which is a fundamental right, but also human rights. So that's it for today. Next time we shall meet again with more facts and more current affairs. Thank you so much for watching.